May I please, Your Lordship?
Yes.
Lordship, I would to mention hearing item number 31. Lordship, in this matter, similar case, SLP has been preferred by the state. So I pray that this matter may be listed after the disposal of the SLP, Your Lordship.
Yes, is it?
A different case, Lordship.
Item 31.
Yes, Lordship.
MS V. Sokri. Learned additional AG submits that in a similar case, SLP has been preferred by the state before the Honorable Supreme Court. And therefore submits that the present case may be listed after the disposal of the SLP by the Honorable Supreme Court. Stop. The same is not objected to by Mr. N. Learned Counsel for the petition. Stop. Is the case after the disposal of the case by the Honorable Supreme Court.
Obliged, Lordship.
Lordship, I have similar prayer for item number 5 to 7. 5 to 7. Here also SLP has been preferred, so this matter may be listed after the disposal of the SLP, Your Lordship.
What does this matter about?
It's word charge regularization, Your Lordship.
Like,
There's an order of the court whereby the AG gave in person, and the AG was directed to justify on the 2004 and 15 OM and place it before the court, but the state has preferred negative.
No, that's a different matter. Different, Your Lordship.
Regulation.
It's a different, Your Lordship.
Interpretation of the 2004 and
No. This is a different one. 5 to 7.
so there should be 5 to 8. 5 to 8.
Yes, my lord.
5 to 8.
Yes.
because the issue of the OM, interpretation of the OM is there.
Similar
Yes,
order?
yes.
Okay, similar.
Much obliged.
May I please, Your Lordship? Lordship, I would mention hearing item number 29, Lordship. Lordship, if this matter can come up after 2 weeks, Lordship.
Why after 2 weeks?
Lordship,
Why?
Lordship, I have some personal difficulty, Lordship. So if Lordship may please release the matter after 2 weeks, Lord.
What is the matter about? Same thing.
Somebody died.
Posthumous regularization.
Yes. When somebody was baptized, he died in harness. And so the family started looking for the family bank.
So first, the posthumous regularization, the
Right.
issue of posthumous. Okay. On the prayer of Mr. V. Jamomi, then government advocate, listed after 2 weeks. Stop. It is made clear that no further adjournment shall be granted in the case. Okay.
Lordship, I also like to mention item number 23, Lordship. Here, I'm yet to receive instruction, Lordship. So if Lordship may please to grant another.
Yes, let it come as per the list.
Yes, Your Lordship.
Yes.
Your Lordship, I beg to mention item 27 from the hearing list, Your Lordship.
Uh,
Your Lordship, here, as prayed earlier, this similar matter is pending before the Supreme Court. The state has filed an SLP, Your Lordship. So this may be listed after the disposal of that matter, Your Lordship.
I hope the government is not taking the shelter of the SLP in other cases.
What I feel is this another court of the decision, division. This will be tomorrow. It will not be. So another court of the this another court that there is a stay. This no stay.
This is item 27.
No,
This is regarding,
Regularization.
this is also posthumous regularization.
no. Give it time. The word retirement, it goes superannuation, it goes without saying that. pension
He was in a work charge employment
Mother,
and he retired from service.
mother.
The issue is whether actually the petitioner complies with, satisfies the scheme
No,
for regularization.
no,
You don't satisfy. You don't satisfy the scheme for regularization. Two thousand four.
mother, prior to that, is another court of sufficient judgment that pension should be given.
So Lordship, as I was mentioning before,
Yes.
the AG was asked to clarify and justify.
In which case? In which case?
Lordship,
27.
in one single
That
case.
matter is listed in, before the, in the virtual court today, Your Lordship, before Devashish Bora, Your Lordship. It's listed today, Your Lordship.
Oh, in that case?
Yes.
Okay.
Because basically the whole issue narrows down to the 4 and 15 OM. Because 15 OM did not supersede the 4 OM.
Uh, But those who retired from service prior to 15 OM will be covered by 2004 AM. I think it's simple as that.
That's how the AG was asked to justify.
On the next date fixed, MS Inaholi, Learned Government Advocate, shall produce the copy of the order passed by the SLP, passed by the Honorable Supreme Court in the connected SLP, listed after 2 weeks. You produce at least some order.
Yes.
Let us see.
Your Lordship, I also beg to
Malo.
mention item number 36, Your Lordship. Here, Your Lordship, on the last occasion, I was asked to bring instructions. And the matter here, it's for creation of posts with regard to the supporting staff of Nagaland State Consumer Redressal Commission, Your Lordship. The matter is with the MRCs. So the MRC has already said, and the MRC has recommended for a committee to be set up, Your Lordship. So I need more time, Your Lordship, because I've
Show
been
him.
asked to.
Show him.
I've been asked to bring instruction with regard to the concrete time frame when the posts will be sanctioned, Your Lordship. Item.
Okay.
Your Lordship, without a
Submission.
specific time, it can take years together also to act upon this. Meeting minutes, Your Lordship is aware of that as observed by this honorable court on the last occasion.
Has the committee been constituted?
Not yet, Your Lordship.
Then?
The letter is that, Your Lordship, that's why I've been asked to bring the concrete time frame by which the post will be created, Your Lordship. But since the committee has not said, I'm seeking more time, Your Lordship, to bring that concrete instruction, Your Lordship. The MRC said on 27th of July, Your Lordship. So on that day, the MRC had recommended for setting up a committee, Your Lordship.
We will give you time. Next time you produce the recommendation of the committee. We cannot sit over the action of the government as to when the committee will be constituted. So we'll give you a time frame. You also tell the government to expedite the matter. This is item.
Item
36, my lord.
Let us see the file. 36. Heard Mr. Retrospective, Learned Counsel for the petitioner, and MS Inaholi, Learned Government Advocate for the state respondents. In the light of the order dated 26/2024, passed by this court, MS Inaholi has placed a copy of the letter dated 17/7/2024, written by the Undersecretary to the Government of Nagaland, Department of Legal Metrology and Consumer Protection, Nagaland Kohima, to the Commissioner and Secretary, Personal and Administrative Reforms Department, Nagaland Kohima, apprising that the Manpower Rationalization Committee, within bracket MRC, in its meeting held on 27/7/2024, has recommended the constitution of the committee to examine the actual number of posts required for Nagaland State Consumer Dispute Redressal Commission to begin functioning. Stop. In terms of the letter dated 17 July 2024, MS Inaholi, the Learned Government Advocate, shall on the next date place before this court the constitution of the committee and the recommendation made by the committee as to the post required for Nagaland State Consumer Dispute Redressal Commission. List the case after.
Your Lordship, 2 months, Your Lordship.
My lord, 2 months would be a little too much.
Your Lordship, the instruction was to bring a specific time frame, Your Lordship. So enough time may be given, Your Lordship.
Okay, we give them 2 months. List the case after 8 weeks.
My lord.
Stop. It is made clear that if no instructions as directed by this court is produced, this court shall be constrained to pass necessary orders against the state respondents.
Flush, your lord.
Stop. The copy of the order dated 17/7/2024 shall be placed on report. Okay.
Flush, your lord.
I also beg to mention item 35, Your Lordship, on behalf of my colleague, Your Lordship. Item 35 here, as per order 47/2024, she was supposed to bring instructions, but the instructions she has not received yet, Your Lordship. So this may be listed after 2 weeks, Your Lordship. Item 35,
Who is the counsel?
AIM, Your Lordship.
MS Inauli, the learned government advocate, makes a mention on behalf of MS AIME, the learned counsel for the state respondents, and 6 for 2 weeks' time to produce the necessary instructions as earlier directed by this court, listed after 2 weeks. Okay.
Lordship, there's an interim, Lordship.
The interim order passed earlier shall continue till the next returnable date. Okay.
Lordship, I may also be allowed to mention item 32, Your Lordship. This matter may be listed after 2 weeks, Your Lordship.
Why?
Your Lordship, a similar matter will be listed after 2 weeks, though it may be taken up together, Your Lordship. WPC 19/2022, Your Lordship.
Is it?
Yes, Lord.
Is it similar?
Yes, analogous.
WPC
19/2022.
19/2022.
Yes, Your Lordship.
This is item 32.
Yes, Your Lordship.
Tag WPC 19/2022 with the present case and listed after 2 weeks.
Much
Blush.
obliged.
May it please my lord. I
Yes.
beg to mention item 37. Hearing. Your lordship, I received instruction only yesterday. So may I pray that 3 weeks' time may be granted.
What is the IA for?
It's for,
Madam, what is the IA for?
For stay, Lordship, but in the process of hearing the matter, this court has given some direction. Then accordingly, Lordship, since we agreed that the IA and the writ petition can be disposed of together.
Okay.
So during the process of hearing, Lordship, we produced one survey report that was conducted. So on that ground, the learned AG has sought time to seek instruction. Well, Lordship, this matter is listed at the hearing section.
Ah.
In case if he's filing his affidavit, then perhaps he can go to be listed for admission hearing.
Have you filed your affidavit?
yes, my lord. This will be my additional affidavit.
Okay.
I received the instruction only yesterday.
Okay, we will keep this matter in the list, in the hearing list. We will give some time.
Lordship,
How much time you require?
May I pray that 3 weeks' time may be granted. my lord.
Mr. L.T. Sankam, learned additional AG is allowed 3 weeks' time to file additional affidavit. Stop, listed accordingly. Okay.
Much.
May I please, Your Lordship?
Yes,
I beg to mention hearing item 34 on behalf of my senior Mojamir. Let the matter be kindly come up on Monday.
34.
Yes, Lordship.
Yes, Mr. MT,
My lord, let it be as a fixed item.
what is the matter about?
This is somebody who was appointed as a night jogger
Night Chogidar.
way
Ah.
back in 2011.
Ah,
Instead of considering his case, a new person was appointed in the
well, what is the nature of appointment? Ad hoc,
fix,
fixed.
my lord.
A fix replaces a fix.
No. It was a regular vacancy in multi-task
Ah,
staff,
MTS. You were appointed as a fixed employee
my lord.
against that post.
I am a night jogger.
Yes,
The MTS is a sweeper.
You are a night Chogidar, MTS is a sweeper.
My lord. So,
So you were removed from service.
no, my lord, because of this honorable court order, I.
No, no, you was by the government's action. The government's action had removed you from service.
Not
What is your prayer?
the other respondent is because of the stay order of this honorable.
Ah,
And he tried not to extend my service as a fixed stay order. So I proved this honorable. If you look at these are not four, and it's still in continue in the fifth state.
This is item
34.
34.
okay. On the prayer of Mr. Your good name,
Indi Noksham.
Mr. So. The learned counsel for the respondent listed on, what is Monday?
29.
Listed on 29/7/2024. Okay.
Much obliged.
Please, Lordship. Lordship, I beg to mention hearing item number 28, Lordship.
Ah,
Lordship, if this matter may be listed after 2 weeks.
why?
Lordship, my senior is indisposed.
Okay.
Lordship.
Mr. Swenson makes a mention on behalf of Mr. Tongpo Pongoner, learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks on the ground that the counsel for the petitioner is indisposed. Where is allowed? Listed after 2 weeks.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next returnable date.
Obliged, Lordship.
Lordship, I beg to mention item 43. My senior is indisposed. Kindly allow 2 weeks
Who is
time.
your senior?
Wati Jamir. I'm for respondent number 7.
Mr. Swenson, learned counsel makes a mention on behalf of Mr. Wati Jamir, the learned counsel for the respondent,
7.
and seeks adjournment of the case after 2 weeks on the ground that the learned counsel for the respondent is indisposed. Where is allowed? Listed. Okay.
Right.
Bless.
Please, Lordship.
Yeah.
My lord, I beg to mention here in item number 39. My lord, let this matter be listed after 2 weeks, Lordship. I am for the respondent number 5.
What is the matter about, ma'am?
Lordship, here we are challenging the order passed by the ADC, Lordship. This pertains to a boundary dispute, my lord.
Boundary dispute.
Yes, Lordship.
Will it not be proper to direct the parties to approach the civil court?
Lordship,
If it is a boundary dispute.
yes, Lordship. Between two villages, Lordship.
Because this court may find it difficult to adjudicate.
Hmm,
Lordship, yes, the matter is subjudiced in the civil court,
Yes,
Lordship.
Lordship.
Matter is subjudiced in the civil court.
Yes, yes,
Then why this petition?
Lordship, here actually, this order passed by the ADC, Lordship, here, the ADC has passed an order asking the petitioners to file, to pay a damage compensation of around
Okay,
rupees 12 lakhs,
okay.
Lordship. So we are challenging this order, and this order has been stayed by this honorable court, Lordship.
Or else the issue regarding a title
Yes,
and
Lordship.
interest
Yes, Lordship.
is subjudiced.
Yes, Lordship.
Okay. On the prayer of Mr. So-and-so, learned counsel for the respondent,
Number 5, Lordship.
listed after. On the prayer of learned counsel for the respondent, number 5. Listed after 2 weeks.
Okay, Lordship.
Okay.
In the meantime, if the interim may.
The interim order passed earlier shall continue till the next returnable date.
Much obliged.
Please, Lordship.
Yes.
Please allow me to mention hearing item 41 on behalf of Peace Foreign. The matter may be listed on 30th of July on Tuesday.
Third. July.
Yes, Lord.
Yes, where's Mrs. Cynthia Amar? 30th July. Okay.
Yes, my lord.
Mr. Pakin Richabo. Learned Counsel for the respondent number,
Private respondent 4 to 7.
for the Learned Counsel for the respondent number 4 to 7. 6 adjournment of the case on 37/2024. Where is allowed? Listed accordingly. Okay.
Yeah, please, your lordship.
Yes, please.
I beg to mention hearing item number 26. Lordship, I agree that this matter may be listed after 3 weeks.
26.
Yes,
You are mentioning on behalf of?
Mr. Sintianger.
Okay, Mr. So-and-so. Learned Counsel makes a mention on behalf of Mr. Santi Younger. The Learned Counsel for the petitioner and seeks adjournment of the case after 2 weeks. Where is allowed? Listed accordingly.
Lordship, I also beg to mention item number 10 and 11. Here,
As per the list, as per the list.
Please, your lordship.
Yes.
I beg to mention hearing item number 33.
Huh.
On behalf of my senior, he's out of station.
Who is your senior?
Sir Sidi Jamir.
Huh.
So if the matter can come up after 2 weeks.
MS so-and-so. Your good name?
Asar Rutsa.
Your name is not there.
It's there, lordship. I changed it, but it's yet to be corrected in the cost list.
No, your name is Atsarutsa.
Asar Rutsa. Here it's reflected as Merlin Rutsa.
Merlin Rutsa.
Yes, however, it's already changed.
Okay. MS. Rutsa. Rutsa. The Learned Counsel for the respondent number?
Respondent number 4 to 13.
Respondent number 4 to 31.
13.
30. 6 adjournment of the case for 3 weeks on the ground that Mr. Siti Jamir, the Learned Senior Counsel for the respondent, is out of station. Where is allowed? Listed accordingly.
My lord, I beg to mention hearing item 42 on behalf of key to TC. The matter may be, the can be set after 3 weeks, my lord.
What is the matter about?
It's my then pata was cancelled.
enforcement of department land.
You want to stay over the encroached land?
No, my lord, ex parte order was passed against me by the DC. So I'm seeking direction to seek a fresh proceeding before the
Let us-
DC.
We list it next week on the prayer of Mr. So-and-so. Pakin Richavo, list the case on
If I may, my lord, the council is out of station for a week. So at least kindly 3 weeks.
on 1/8/2024. Yes. He will not be out forever,
For a week, he will be out.
huh? So after a week, we are fixed on 1st. Okay.
Clear by good.
Yes.
Mr. Lordship,
Yes.
I'd like to mention hearing item number 30 on behalf of my senior Moajami. Your Lordship, if this matter can be listed next week.
MS so-and-so makes a mention on behalf of Mr. Moajamil, the Learned Counsel for the petitioner, and seeks adjournment of the case for it. Listed again on 1/8/2024.
Mr. Lordship,
Yes.
Lordship, I beg to mention hearing item number 25 on behalf of AIME. Lordship, I kindly
On
list
behalf
this-
of,
AIME.
what is the matter, Mr.?
My lord,
Kaka.
I'm challenging the appointment of the private respondent number 4 Yes, on the ground that the petitioner case has not been considered on land ownership basis.
Yes, what is your prayer?
Lordship, kindly list this matter after 1 week.
Okay, okay.
My lord.
MS Pichano. The learned counsel makes a mention on behalf of MS AIME, the learned government advocate, and seeks adjournment of the case for a week. Prayer is allowed. Listed accordingly. Okay.
Lordship, I also like to mention item number 38 on behalf of S. Chang. Let this matter be come up after 1 week.
On the prayer of the learned government advocate, list the matter after a week. Okay.
Thank you.
For motion, item number 1.
May I please, Lordship?
Yes.
My lord, the petitioner hearing is assailing the appointment order of the private respondent number 5, dated 28/6/2024. On the ground that the case of the petitioner has not been considered on land ownership basis. My lord, the short facts of this case is that in the year 1965, a group of 10 landowners has donated a large portion of the land for establishment of a potato seed farm at Pongro. And thereafter, in the year 1966, a land agreement was signed between the landowners and the government of Nagaland. But therein, in that agreement, there was a specific condition that the landowners will be considered for the different privileges. My lord, after the donation of the land, 58 years has elapsed. But till date, the case of the land ownership for appointment on land ownership has not been considered. My lord, here, the private respondent was appointed. The private respondent's father was also working as a grade 4 employee in the same establishment. My lord, from 1966 till 2017, it was running as a potato seed farm. And since 2018, it is under the establishment of sub-divisional agriculture officer. My lord, that 1966 agreement had become ineligible. And as such, in the year 2021, after the establishment of the SDO office, the 1966 agreement was retyped, wherein in that agreement, there was some additional thing were added, wherein it is clearly mentioned that none of the landowners were appointed till date, that means till 2021. Thereafter, in the year 2023, the petitioner's father took voluntary retirement. And as such, the petitioner also applied on land ownership basis. However, without considering the case of the petitioner, the department has again appointed the petitioner, which means the respondent's family, the private respondent's family, are enjoying this benefit for the third generation. His grandfather was appointed as grade 4 employee. His father was also appointed, and now the respondent is being appointed as grade 4. So they are enjoying that benefit for the past 3 generations.
It was through an interview.
Yes, my lord. My lord, that advertisement, not interview, exactly not interview. That advertisement was not published in the newspaper. My lord, it was published in the department's website, number 1. My lord, that will not suffice, that will not meet the requirement of Article 16 of the Constitution of India.
Heard, Mr. Takakichu, learned counsel for the petitioner. The present petition has been filed, seeking to quash and set aside the advertisement dated 26/2/2024, inviting applications for filling up 19 posts of multitasking staff, and 1 post of tractor handyman under the Department of Agriculture,
My lord, I have imbued only the item number 9, that is in respect of FPO only.
Yes, what was that? No. Oh, censor. More particularly, the post of MTS Mali under SDAO Pungru, which is serial number 9 of the said advertisement, comma, the letter dated 28 June 2024, granting administrative approval for 19 posts of MTS and 1 post of tractor handyman. More particularly,
Serial number 16.
with regard to serial number 16 of the said letter, and
Page 35, the appointment order.
and the notification dated 28/6/2024, appointing the respondent number 5 as multitasking staff within Brigade MTS in the subdivisional agricultural officer Pungro under the Agriculture Department. It is the case of the petitioner that, being one of the bona fide landowners, he has a right to be considered for appointment to the post in which the respondent number 5 is appointed. Stop. Issue notice to the respondents,
1 to 4, Your Worship. 1 to 4.
returnable after 4 weeks. MS Inaholi, the Learned Government Advocate accepts notice on behalf of respondent number 1, 2, 3, and 4. Therefore, no formal notice need be issued. The Learned Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Learned State Council within
2 days.
within a period of 2 days from today. Insofar as the respondent number 5 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
3 days from today.
within a period of 3 days from today.
My lord, I'm also praying for a stay of the ambient appointment.
No. Appointed, already appointed. Let us see. Let us consider your case on merit.
For motion, item number 2.
Yes, Mr. Likasi, what is this?
My lord, I'm seeking direction for appointment on land ownership basis, my lord.
Somebody has been appointed,
No, my lord.
then?
My lord, I've donated the land way back in the year 2003. But after waiting for more than 20 years, the state respondent has not considered the appointment of the petitioner on land ownership basis. my lord.
Where is the post to accommodate you?
To any of the grade 4 posts, my lord.
To any, how can you say that? How can you make that submission to any of the grade 4 posts? The post has to be first created before you can be considered.
It's very, my lord, difficult to find out whether the post is lying vacant. or
Has
not.
anybody been
Yes, my
appointed?
lord. No, my lord, no.
Then that means there is no vacancy. If somebody is appointed and you are aggrieved by that appointment, you can always come before this court.
Yes.
But when there is no vacancy, what is the question of considering your appointment? And where are you seeking the appointment?
At Sejong, my lord.
At Sechong.
Yes, my lord.
In which department?
Police, my lord, under police establishment. My lord, there is an OM that land ownership be considered on the basis of the land donated at free of cost, my lord, for establishment of the stadium.
Yes,
Yes, my lord.
there is no dispute. There is no
Yes, sir.
dispute, but there must be a post to let that OM operate. Without any post, that OM will not operate. I think you are filing a premature petition. Okay, anyhow, let us issue notice. Mr. L. Likase Sankan, learned counsel for the petitioner. The present writ petition has been filed. Invoking the notification dated 16/8/2018, correct?
Yes, ma'am.
For appointment to any grade 4 post in the office of
Superintendent of Police, respondent number 4, my lord.
the superintendent of police at
Kifri, my lord.
at Kifri. Okay, issue notice to the respondents. Returnable after 4 weeks. MS Chano, learned government advocate, appears for the respondent number, appears for all the respondents. Therefore, no formal notice need be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
Because of the email.
in the course of the day. Okay.
A pleasure. For motion, item number 3.
Yes, Mr. Likase.
Yes, may I please, my lord. My lord, here due to oversight, There's some discrepancies in the prior portion, my lord.
Okay.
Yes, so I may be allowed to withdraw with liberty to file afresh, my lord.
Okay. But as it is, you are challenging your termination.
No,
Termination from
that is
service.
different, yes, my lord.
Oh,
That
is
is
it?
different, yes, my lord.
So that case is implanted here.
No, my lord, that is in item number 4. Yes.
Okay. Mr. El Likasi, the learned counsel for the petitioner submits that he may be allowed to withdraw the petition with liberty to file afresh. Stop. Petition is allowed to be withdrawn with liberty to file afresh.
Okay.
For motion, item number 4.
Yes, what is this? A long story.
Yes, my lord.
What is all this?
My lord, here the petitioner has filed this writ petition on behalf of one Master Penrithong Mule, my lord, who is a minor, my lord. My lord, for clear picture, may I take your lordship to para number 2, my lord.
Yes.
May I read, my lord?
Yes, please.
That the petitioner grabs the leave of this dishonorable court to file the incendiary petition on behalf of Master Penrithong Mule, as he is a minor who is 16 years old, whereas the petitioner is the cousin brother and a guardian to Master Penrithong Mule, and petitioner is the nephew of late Monlumo Lota, that is the father of the minor, my lord. So, my lord, annexure A is the birth certificate of the minor, my lord, who will be completing 17 years in the month of September, my lord, this month. And my lord, what happened is that, my lord, the petitioner, the minor father, who was serving as constable under the establishment of the respondent number 3, that is 8 NB Battalion, Naldoga Zenepoto, my lord. He was terminated from service. That is page number 13, my lord, Annexure C. And type copy is at Annexure 13, page number 13A, my lord. May I read, my lord? Government of Nagaland, Office of the Commandant 8 NAB Battalion, Naldoka, Nagaland. Bearing number so and so, dated Naldoka, so March 2008, my lord. Order, whereas number so and so Constable Monglumo Lota of this unit found absent from government bona fide duty with effect from 26/10/2007 without any leave or permission from the competent authority, whereas calling notice was issued and served to Constable Monomo Lota to report back within 7 days from duty so and so. For duty, white calling number so and so, that is so and so, and the answer, and the same was also published in leading daily local newspaper, White Nagaland Post, volume so and so.
Mr.
Yes, my lord. Yes.
What is precisely your case?
My lord, here, this the minor father was expired, my lord. Was expired before the discharge order was issued, my lord. And thereafter, the mother of the minor, who is the respondent number 4 in this present petition, my lord, has approached this honorable court by filing writ petition number and WPC 221 of 2019, my lord. Here in this writ petition, the respondent number has challenged the dismissal order, and whereby this honorable court has allowed by setting aside the dismissal order, and direction was given to the state respondent to grant pensionary benefits to the respondent number 4. But in the meanwhile, after the disposal of the read petition number 221 of 2019, the petitioner family came to know that the respondent number 4 has approached this honorable court, and the family of the respondent number 4 and then the petitioner family sat together, stating that as the respondent number 4 has remarried to other men, so she will not be entitled for the benefits of the.
So basically,
So
you're
now
seeking for the pension and service benefits of that late
My-
constable.
Yes, my lord. And my lord here, after the order of this honorable court, the petitioner along with the minor, on behalf of the minor, the petitioner went to approach, approach the respondent number 3 along with the succession certificate and a representation to grant service benefits as well as the pensionary benefits to the respondent number 4. And the respondent number 3 has informed the petitioner to come along with the respondent number 4 to settle the issue before the respondent number 3. And that's how the the petitioner and the respondent number 4 went before the respondent number 3, and in front of before the respondent number 4, the respondent number 4 has stated that as she has been remarried to some other man, so she has no claim over the benefits of her late husband. So that's how that was settled, and to submit the affidavit stating stating that she has no claim over the benefits. So accordingly, the petitioner cousin, who is minor, and the mother executed the affidavit, which is annexed at Annexure G, my lord, page 23. They have submitted that the respondent number 4 has relinquished all the claims of her late husband. But thereafter also, the respondent number 3 has informed that the court order was in the name of the respondent number 4. So the minor, the court order has to come in the name of the minor. So that's how the grant has been stuck up. And I'm here before this honorable court seeking
Mr.
direction.
Mua, why don't you advise the department to pay the pension and pensionary benefits to the minor son of the deceased? That settles the matter. Why actually stretch the matter so long? See, what the Learned Counsel for the petitioner is submitting is that since it is the wife of the deceased government employee who had filed the case,
Correct.
where she was successful.
Yes. Now, wife has filed the case.
Ah.
This is permanent employee. This is policeman. And by way of this WBC 221 of 2019, the wife of the deceased has approached this court.
Yes.
Now there was a contest. State has filed the counter affidavit, and there was a contest. I was there, and accordingly, this honorable court has allowed the wife of the petitioner, the wife of the deceased constable, to take all the claims, like the succession certificate and all that. Now his grievance is now he's coming against the minor. His allegation is that the wife of the deceased constable was remarried again to somebody, leaving all the children to the petitioner under the care of the petitioner. Since the minor, since the son is the minor, it is in the form of his uncle. He is coming. The present case is like this. Now, what they are asking, the authority is asking, is also seems correct, because court order is very clear.
This court order was in the name of the wife.
In the name of the wife.
Who has waived all her rights? Who has waived all her rights to claim the pension?
That is what the petitioner is saying now. That is what the petitioner is saying now. Because wife is indicted as a party respondent number 4 here.
Okay.
So since they are afraid that since the court order is very clear to succeed the deceased constable by the wife. Now again, you need another court order. That's why he is coming, petitioner is coming.
Yes, my lord, since the,
Because court order is very clear. It was contested by the department, and it was accordingly given to the wife.
Is there any procedure to change the name of the nominees in the service book of the deceased government employee?
Because succession has been given to the wife.
no, my lord, succession is in the name of the
Minor.
minor. Yes,
Ah.
my lord.
Succession has been given in the name of the minor. That is why instead of actually going through all these rounds of litigation, whether there is any other convenient way of allowing the petitioner to claim the pension.
And also, my lord, there is a letter issued by the village council.
No, village
Yeah,
council, forget
yes.
it. Village council is no concern for pension and pensionary benefits.
No, it's that the wife is remarried, so that's what they.
That let the wife
Yes.
come and say, if
Yes.
you are making the
Because
delegation.
he is saying that he is married. I don't know. The wife of the.
I also don't know.
I don't know. No, let us go for the notice, whether he is remarried or whatnot.
Okay,
Let us go for
okay.
notice.
That Mr. L. Likhase Sanktam, Learned Counsel for the petitioner. The petitioner hearing is the legal guardian of Master Ben Rathan Mule, son of late Munglomo Lotha. The petitioner by filing this petition is claiming the pensionary and other service benefits of late Munglomo Lotha. Who was serving as a constable under the establishment of the commandant, 8 NAP Battalion, Naltoka, Zeneboto, Nagaland. Stop. Issue notice to the respondents, returnable after 4 weeks.
Lordship, I'm representing
Yes.
state respondent.
1 to
1, 2,
3.
3. 4 is the wife.
Yes.
4 is the wife.
Mr. Mohamchan, the Learned Senior Government Advocate, represents the state respondent number 1, 2, and 3. Therefore, no formal notice need be issued to the state respondents. Stop. The Learned Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Learned Senior Government Advocate within
Course of the day, man.
in the course of the day. Insofar as the respondent number 4 is concerned, the Learned Counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within
3 days, man.
a period of 3 days from today. Okay.
For admission, item number 9.
Yes.
May I please, my lord?
Yes.
Lordship, when this matter was listed on 2/7/2024,
Correct.
the Lordship, I have submitted some oral instruction that I received from the department. And your Lordship, by an order of this honorable court, I was asked to place those instructions in the form of an affidavit.
Huh.
With sincere apology, your Lordship, I did not file my affidavit for the reason being, your Lordship, after the matter was listed on 2/7/2024, some more development have taken place, your Lordship.
What is the development?
Development now, your Lordship, almost everything is done. The department is reconstructing the service book of the petitioner. And once it is done, it will be placed before the Accountant General Office, your Lordship. There is a last stage, your Lordship.
So the new development is the reconstruction of the service.
Yes, yes, your Lordship.
Yes, Mr. M.T. Longchair, you have a good news?
The time frame.
So if some time can be granted to us, my lord, so that we can reconstruct the service book of the petitioner and then send it to the Accountant General Office to let them process the extraordinary pension, your lordship, that the state government have granted.
The fact is that, my lord, we are still holding with this honorable court judgment order dated 25/7/2011.
Yes.
They are still making.
Your claim in this petition is for extraordinary
My
pension.
lord, yes. 25/7/11, this honorable court has already given the directive.
So, Mr. Anangami,
Lordship.
how much time will be required? Approximately, we give you the last chance. I think these are actually pension matters, and then we have to expedite the matter.
Yes, correct, your lordship. In fact, your lordship, by an order of the state government, extraordinary pension has already been granted.
Okay.
Yes, your lordship, by an order dated 21 January 2012. What took so long was, your lordship, everything was placed before the Accountant General Office. However, the Accountant General Office returned back the pension papers to the government on the ground that the service of the petitioner was not regularized. But here is the case where the order was not related to the family pension. It relates to the extraordinary pension, where the employees need not be a regular government servant. That is why it took time. Now, your lordship, by a letter, your lordship, 31st of
31.
30/01 of 2024, the Accountant General Office have asked us to reprocess the entire pension papers back to the Accountant General Office. So we are now, your lordship, reprocessing it.
Mr. Inti Longjam, the learned counsel for the petitioner. Mr. Anangami, the learned senior government advocate for the state respondents, and MS Wenso, learned counsel for the
Respondent number 5.
for the respondent number 5. On 2/7/2024, this court had desired that the oral instructions received by the learned senior government advocate may be placed on record in the form of an affidavit. Today, when the matter is listed, Mr. N. Angami, the learned senior government advocate, submits that the department is reconstructing.
Yes, your lordship.
Reconstructing the service book of the petitioner.
Deceased, my lord. Deceased.
Of the deceased,
Yes.
of the deceased employee.
Yes.
And will be sending the same to the Accountant General's office for payment of extraordinary pension to the petitioner.
Authorization by the. Without authorization, the department cannot. To be authorized by the
For?
AG.
Yes.
For authorization by
Lordship.
the AG for payment of extraordinary pension to the petitioner.
Lordship.
How much time?
Lordship, if
This will be the last chance given to you.
not 2 weeks, your lordship. At least if 6 weeks can be granted, my lord.
On appointed query as to what would be the time required for completing the process to entitle the petitioner to receive the extraordinary pension. Mr. N. Angami submits that at least 6 weeks time
Lordship.
will be required for completing the entire process. Stop. In the light of the submission made by the learned senior government advocate, 6 weeks time is granted to the learned government advocate, to the department, to complete the entire process for enabling the petitioner to receive the extraordinary pension. It is made clear that if the process is not completed within the period of 6 months, this court shall be constrained to pass necessary orders, including imposition of substantial cost. Listed after 6 weeks.
Much obliged.
I'm deeply obliged. my lord. For admission, item numbers 10 and 11.
Yeah, please, your lordship.
Yes, please.
In this matter, pleadings are completed, so lordship, it may be listed for hearing.
What is the issue?
Lordship, I agree on behalf of ACRA.
The Advocate General was requested to address the court on the issue raised in this petition. Mr. Tenangabi, what is the issue raised in this petition? And why was the presence of Advocate General required?
Lordship, the matter relates to regularizations of the petition service in terms of the office memorandum, if I'm not mistaken, Your Lordship. Lordship, in fact, today, I think this is one of the matter, Your Lordship, where the Advocate General is, yes, Advocate General is addressing the court through VC, where he has been asked as to the applicability of the Office Memorandum 2004, as well as Office Memorandum 2015, Your Lordship. If this matter can be listed after the AG give his views, Your Lordship.
What is the matter about in this writ petition? What is the matter about?
For regularization for pensionary benefits.
For regularization of?
The service of the petitioner in terms with Office Memorandum 17/3/2015, Your Lordship.
So simple as that, whether the petitioner qualifies.
Yes.
The condition.
Yes, Your Lordship.
It is not necessary to wait for other cases.
Correct, madam.
If the issue is whether the petitioner qualifies the Office Memorandum 17. That is the issue.
Correct, correct.
Whether the petitioner qualifies or not.
Correct, madam.
How long has the petitioner been serving?
35 years.
35 years.
He has retired.
Yes.
He has retired.
Yes.
Whether
Retired in 2019.
2019.
Yes.
Whether he was getting a fixed or scale pay.
Fixed pay, Your Lordship.
Fixed pay.
Yes, my lord.
Then in that case, he does not qualify the Office Memorandum
Yes.
2015. Simple as that. You were appointed against a regular vacancy.
Lordship, for WBC 303, the petitioner, he was on scale of pay.
And when was the scale of pay granted?
Lordship, apologies, it's fixed. It was on fixed pay. He was appointed on fixed pay.
And he retired on fixed pay.
Yes, my lord.
So he does not qualify.
Yes.
Office memorandum 2015 says that one should be in a scale of pay. And he should have completed 30 years
Of
in
continuous
a
service.
regular vacant post
Yes, yes, Your Lordship.
on a scale of pay. If that criteria is satisfied, then we can, of course, hear the matter. If not, I think you have no case. Tell MS Mary to come next week. We are fixing it next week. We will not wait for any other pending cases.
Lordship,
She's engaged before court number 3.
That's next week also she'll be engaged.
yeah. Otherwise, Your Lordship, after her matter is done, if this can be listed, after the listed matters,
Okay.
since all the parties are here today, my lord.
You are mentioning on behalf of?
My senior, Mr. Sindianga.
Tell Santi Younger to be here next week.
Okay.
We are not giving any adjournment.
Lordship.
With or without Mr. Santi Younger, we dispose. On the prayer of the learned counsel for the parties, listed again on 29/7/2024. It is made clear that there shall be no further adjournment in the case.
Give you obligation.
Yes. Tell Miss Mary to come
Lordship.
on that day.
Lordship.
For admission, item number 12.
Lordship.
Yes.
Lordship, on behalf of Ace Chung, can you list this matter after 3 weeks?
Why 3 weeks?
Lordship, her pleadings are completed, Lordship.
Okay. Pleadings are completed.
Yes, Lordship.
Lordship.
What is the matter about? Same.
Yes, Lordship, the petitioner is praying for regularization in terms of OM 2024.
2014?
2004.
2004.
Yes, Lordship.
You have retired or you are still in service?
I'm still in service, sir.
You are still in service.
Yes, Lordship.
How many years?
More than 18 years now.
More than 18 years. What is the criteria laid down by
Lordship,
2004 notification?
I'm applying for regularization after the demise of one late or non-BAP home.
Are you the senior most?
Yes, yes,
Are you the senior most?
Yes, Lordship.
You are mentioning on behalf of N. Longber?
Yes, Lordship.
Who is appearing for the state?
Ace Chung.
Yes, MS so-and-so, Mr. So-and-so, learned counsel, makes a mention on behalf of Mr. N. Longmer and seeks adjournment of the case after
3 weeks, Lordship.
after 3 weeks. It is also submitted that pleadings are completed and the matter can be listed for hearing. Listed for hearing in the usual course.
Obliged, Lordship.
For admission, item number 13.
Lordship, I'll be filing my affidavit tomorrow, affidavit in position tomorrow. I just received, I'm going to receive today, Lordship. For private respondent number 3.
Whether the government has filed? Your good name?
Mr. Kachishi, Lordship.
Mr. Nisikachishi. Learned counsel for the respondent number
3, Lordship.
3 submits that affidavit in opposition on behalf of
Private respondent number 3.
the respondent number 3 will be filed shortly and therefore 6 for 2 weeks time. Where is allowed? Listed after 2 weeks.
Much obliged.
For admission, item number 14.
Milits.
Yes.
Milits, I am from Delhi. I am privileged to appear before my lords.
Yes.
Very limited issue, Milits. Same, my
May-
lords is considering all those matters.
Your Lordship, before the learned counsel continues, Your Lordship, here the pleadings are complete, Your Lordship. But here the same matter is listed before the CJ in the principal bench, Your Lordship. But this is with regard to regularization of contingency employee, Your Lordship, who is retired, Your Lordship. The same issue is with the CJ, Your Lordship, and it's pending. I can give you the number, Your Lordship.
Yes,
And AG
Mr.
is
If it is
appearing in
pending
this case.
before CJ, before division bench. Before
That's a
division
different-
bench.
That's a
Yes, Your
different
Lordship.
issue, Milits. I am raising different issue.
What is your issue?
My issue is, Milits, I have been treated as a bonded labor, number one. My all human rights, my all fundamental rights have been violated. My minimum
What is,
wages-
okay, let us forget about that aspect. What is the facts of this case?
The facts of this case is, Milits, that I have been made to work for 35 years on a wage or employment of whatever remuneration or salary, which is not even in conformity with the Minimum Wages Act. The state of Nagaland is, I mean, without any compunction, violating the law
In
of
the
the
state
land.
of Nagaland, there is a scheme. I think that scheme,
Milord, in that case, my name was forwarded, but the government, the finance department did not agree. So the limited issue is that
there are thousands of employees like you.
maybe Milords.
And
that is very serious
all
matter,
the-
Milords, if
all
the
the
state is
cases are
abusing.
pending. All the cases, that is why I think.
No, I have seen
also-
Milords. My lords is perhaps
We have,
addressing
we have, I
similar
think,
grievances.
About 40, 50 cases are listed on that issue.
Yes, Milords, I think I'm hearing my lords is
And if it is
addressing.
listed before the.
But Milord, the
division
issue here which I am raising, which required my lords are
bench, I've
constitutional
understood.
court.
I've understood.
I'm raising a different issue altogether, Milords.
But when the same matter is pending before the CJ.
No, that's some different issue. My associate
No,
tells
it
me.
is, it relates to contingency employee.
Yes, Your Lordship, the same case, Your Lordship. Same
So maybe it may not be proper for this court to take up.
No, if the similar matter is being considered by a division bench led by Honorable Chief Justice, then of course. a
What is
single bench-
the, what is the case number?
It's WA number 68,
Ah.
2021.
So if these matters are pending before CJ, and
Not
if this
matter,
court has
Milords.
been
My lord,
informed.
This is a matter which was instituted in 2023. And in counter millets, counter of the state, there is no such averment. What my learned sister is saying now,
You are from Delhi, you may be new to this fact situation.
maybe.
You
millets-
may have a submission, but you may be new to this fact situation.
No, millet, but that is not stated in the
So-
counter millets, or otherwise we would have consulted
There are,
that
there
petition.
are
and-
hundreds of cases pending in this court on that issue.
That's every high court,
And
maybe.
this court has also passed so many orders, but some has landed in appeal before the Honorable Supreme Court. And some still pending before the Honorable Division Bench.
That will, individual cases will always be like that only, millets.
If-
In that
if,
case, millet, may I have, I bow down, millets. If the state feels that issue is already under consideration of a division bench of the Honorable Chief Justice, and this will be covered, if that is decided, my case will be covered. Probably that is what my learned sister is saying. In that case, millets, I'm an employee who has attained, he's about 66 years old. The life expectancy of the female in Nagaland, woman in Nagaland is around 70 years. Millets, I am starving, I am on the road. They should give me something at least for my bare survival. Milord, we are doing this case pro bono since the issue is so stark. So I agreed with my
When
associate's
the matter
request.
is pending, this court cannot give any direction to actually.
So in that case, Milord, my lord should consider, because they have not taken this plea. For the first time, she is raising this plea in the counter affidavit. There is absolutely no whisper.
This matter now has been brought to the knowledge of this court. So
Yes, Milords, I
maybe-
agree, Milord, in that, but in
What
that
is the
case,
case?
Milord,
Let us see.
my applicant, Milord, in that case, Milords, my.
Let us see.
Yes.
Let us see the case.
Your
Yes.
Lordship,
The number.
WA number 68, 2021. Your Lordship.
WA
68, 2021.
21 minutes.
21. State of Nagaland and two others versus Pihoto Sema.
Milords, if the prayers are the same, then I will bow down, Milords. Not that I'm outside the judicial discipline, but subject to that, Milords, Milords may kindly consider.
What is your fake? What is your case?
My case is simple, Milords.
Don't talk about bonded labor. Don't talk about
All right,
those
Milords,
humanitarian
simple,
grounds.
bare-
Give me the facts.
Yes, Milords, bare facts. I was employed as a sweeper on 22nd of July, 1984. For 6 months to begin with, And because of my satisfactory performance, my services kept being extended by the employer state, and it went on till June 2019. There is a circular by the state of Nagaland which says that you cannot keep an employee beyond the age of superannuation. Superannuation age is 60 years.
That is obvious. That is
Obviously,
obvious.
so on 30th June, since I was completed 60 years, I was asked not to come back for the service, or I was terminated, or my services were discontinued. I mean, word is not material. Thereafter, Millard, since this poor lady was not aware of law, any rights or anything, so somehow she came in contact with my associate, Mr. Lotha, who is from her community. Then he discussed this case with me, and then last year in 2023, we invoked the jurisdiction of my lords. So I am saying, Millets, this is absolutely abusive. I'm on the Minimum Wages Act, Millets. The state cannot take the services. The state is a model employer, and the state it is not a commercial organization. It has other obligations also under the law. It is the enforcer of the law. It is the creator of the law. Now it cannot violate its own law.
That would have been relevant if you are still in service. You're out.
I'm out because no, Millets.
What are you claiming in your petition?
I'm claiming the regularization of my service, which was proposed by my department, but was rejected by the finance department.
Whether this court has the power to retrospectively regularize?
Yes, Millets.
No.
Article 226.
As per case.
Millets, writ court can do it, Millets.
As per Umadeva's case, this court has no power. We are powerless to retrospectively regularize you.
Millets,
please make correct submission.
In that case, Millets, in that case, I'm not beyond the court. Millets, in that case, at least minimum wages should be given to me for the services rendered.
But let us see. Since the Honorable CJ sees of the matter, let us see. Maybe you will get a better relief there. Let us see.
I don't know, because I'm just not aware what is the prayer in that writ petition. I will probably request my sister to give me a copy of that writ petition if she can.
Do you have a copy of that writ appeal?
No, Your Lordship.
Can you furnish it?
Let her file in the court, Millets, in that case.
Yes, ma'am. Yes, please.
That case is also similarly situated with the present petitioner. In that case, she was a contingent employee under the school education department.
Correct.
She approached the court saying that she should be regularized, Your Lordship. So, Your Lordship, since we do not have any scheme, though we have the scheme for the work charge employees, we do not have the scheme for the contingent employees. So she cannot be considered. So this single judge has given a direction that her service should be regularized. For that matter, the state has filed an appeal, and it is not.
It is an appeal, Millets.
See, Mr. Leonard.
No, Millets.
Listen. Even in this case,
Millets,
there are diverse judgments. Some granting favor in favor of such employees, some against. So let the division bench.
I bow down,
At
Millets.
least let the division bench give a clear-cut direction as to whether such employees are eligible to be regularized in service or not.
Millets, I bow down, but the facts are what my sister is telling is that this learned single judge of this honorable court has given a direction to the state to regularize, which the state is agreed, and the state is contesting its correctness before the honorable division bench.
Correct.
Millets, if the order of the learned single judge is not the state by the
It's already stated.
state.
Yes.
So in that case, Millets, if it is a state, and if my facts are the same, in that case, Millets, I will have to wait for the.
Please do that. I think we should not.
In that case,
Millets,
Millets, that I'm saying, in that case, let them file the copy of the writ petition before this.
Okay,
honorable
MS
court.
Inaholi. Next day to file a copy of the.
I will assist my lords. No harm will visit. If the facts are the same, we will wait for the. And if order is a state, then probably I cannot press for the relief. What I'm saying.
Yes. Whether the petitioner, Your Lordship, has the liberty or the right to seek for that petition, Your Lordship.
No.
Yes,
I
Your
would let
they are stalling my petition on that, and they are not able to file.
You can
That's
just file
can't be the
a
law.
one-line petition saying that enclosing a copy of the.
Yes, they can just file it as a document also. No issue.
Or as a document. That's okay.
That can be filed as a document also, Millets.
Your good name?
I'm SK Srivastava, Millets, with my associates.
You are a senior designated counsel.
I'm not declared senior, Millets, but.
Okay. Third, Mr.
SK Srivastava.
So-and-so, learned counsel for the petitioner, and MS Inaholi, learned government advocate for the state respondents. In the course of hearing, MS Inaholi submits that in a similar matter, the state has filed writ appeal 68/2021, and the same is pending.
Well, let's may record the fact that the order has been stayed by the London Single
And
Judge. Because that house.
please wait.
My lords, my lords.
What was that, Mr. Kipi? Before the Honorable Division Bench at the principal seat. MS Inaholi also submits that the judgment passed by the learned single judge there has been stayed.
Lordship, that is but I have not seen the record, so your lordship, that may not be put on record.
No,
so
my lord,
lordship, that may not be put on record. If
Okay.
there is an stay, they can always.
Okay, Mr.
check on
Cancel
the
that.
website.
Well, let's see if it is not stayed, then I'm entitled to the relief, with due respect.
MS Inaholi is accordingly directed to produce the copy of the writ appeal 68/2021
Along with the
on the
orders.
next date fixed in order to let this court ascertain as to whether the matter before the division bench and the present writ petition is similar. Listed again on, yes, when do you want it?
Maybe sometimes in August minutes.
Listed again on. '22.
Not 22 minutes, 22 will be difficult. Millets can have it, will it be possible, Millets, rather 19th of, or 26th of August, Millet, because. I
Listed
will-
again on.
It's a holiday, your lordship.
26 is a holiday.
26 is holiday. Oh. No, then 26, this is holiday. Actually, Millets, I will need one day to travel, that's why I want to club it with some holiday and. So 30th, Millets.
30th.
Millets, rather, can I ask for 19th Millets?
Listed again on.
19 is also a holiday.
19 is a holiday. 19 is a holiday.
Oh, Millets, I'm sorry. Not 23, not possible. 23, no, I'm in Patna.
Listed again on 30.
Millets can then give me date on no, I think, on 4th Millets, 4th of September.
Listed again on 4/9/2024.
24 minutes.
Okay, next.
Much obliged, Millets.
Yes. Yes, excuse me for 2 minutes.
For admission, item number 15.
My lord,
Yes.
I have received the instructions just few days ago. I'm under preparation about the affidavit. So may I pray that
What is the matter about?
It's about the posthumous regularization. Filed by the deceased wife.
Work charge employee?
Yes, my lord.
Yes, madam. This Nishevi's case.
Yes, ma'am.
This is in connection with 2004 or 2015. Nishevi's case.
It's about 2022.
Lordship, I think, I'm not sure, but I think it's 2004. I think.
Four.
Yes, yes.
I also remember.
Yes, it was. During his lifetime also, he does not come within the purview of.
That's yes.
regularization.
That's.
So it's considered that.
So whether whether Nishevi's case will apply to those cases covered by 2015.
Lordship, regarding with the posthumous regularization, I think that the principle will happen.
In Nishevi's case, the contention of the state was upheld. In Nishevi's case,
Yes, yes.
stating that the person who had served for so many years is not entitled to posthumous
Yes,
regularization.
yes, yes.
Okay, you file your affidavit.
Yes, my lord.
You have all those citations in your favor.
I may be granted 3 weeks time, my lord.
Why 3 weeks? You have
I have
already
received the instruction only recently. just
only
few days ago.
recently. Mr. LT something. Learned additional AG submits that he has received the instructions only recently and therefore seeks for 3 weeks time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
For admission, item number 16.
Please, my lord.
Yes.
My lord, in this petition, lordship, pleadings are completed. It may be listed for hearing, lordship.
It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Stop, listed for hearing, the usual course.
For admission, item number 17.
Yes.
May I please, my lord?
Yes.
Lordship, in this matter, the affidavit is under preparation. If 2 weeks' time can kindly be granted to me, my lord.
Mr. Enangami, the learned senior government advocate submits that the affidavit on behalf of the state is under preparation and he would require 2 weeks' time to complete the process and file the same. Prayer is allowed, listed after 2 weeks.
Deeply obliged, my lord.
For admission, item numbers 18 to 19.
Your Honor,
Yes.
if I may, we are the petitioners in person for today's case, item 18 and 19. Your Honor, on 6/6/2024, the court passed an order directing opposite party number 7, Ms. Neto Kozo, and all other parties to file their affidavit in response to our IA 58 and IA 65. sorry, IA 65 only. But no reply has been filed as of now, and it's almost 2 months.
Opposite party, madam, you're
Lordship.
opposite party number 7.
Lordship, in IA 65, Lordship. I have not been served a copy, Lordship. How do I find my reply, Lordship?
Your Honor, she accepted service on that day, on
Yes,
6,
I
6,
accepted notice,
2024.
but the copy was not given, Lordship.
Madam,
Yes,
I think you should differentiate between notice and copies.
Your Honor,
Notice without copies
Yes.
of the application
yes, Your
will
Honor.
not complete the process of notice.
In fact, in order to save them some
So
money,
kindly complete the process later, at least I explain you are,
Your Honor, we did serve notice on the
did you serve the
advocate.
copy
Yes, Your
of the
Honor.
application?
Yes, Your
Any
Honor.
proof?
We posted it via
And-
registered post. Hold on one minute. To her office, because we don't have her personal address, of course.
Serve today, serve today. Serve a copy today.
Okay, Your
Let
Honor.
us stop that controversy, serve the copies today.
We did serve it. It was
No, you
delivered.
serve today. You serve today.
Okay, Your Honor.
Have you got extra copies? Have you got extra copies?
I don't think so, Your Honor. I don't have
How-
unmarked
How many
copies.
pages is your application? How many pages is your application?
Your Honor, we served notice on her. We
I am
sent it to
asking
her
you,
office.
kindly answer the court.
Par-
I am not
pardon.
here to listen to you. I want you to answer.
Yes. Could you repeat, please?
How many pages is your application?
Um, 65. It is.
You serve the copy in the course of the day. Serve the copy in the course of the day. And receive the acknowledgement, with acknowledgement from the Learned Council.
It's 44 pages, Your Honor.
Yes, 44 pages I have sent.
Yes.
It's quite lengthy. So you serve the copies today, okay, ma'am?
Lordship. Lordship,
And you actually kindly acknowledge.
Lordship, I will do that, Lordship.
Ah.
But Lordship, kindly allow me to apprise this court, Lordship.
Ah. No,
Similar-
without your affidavit, without your counter.
Lordship, a similar proceeding is pending before the State Bar Council. Before they file the application, they file a complaint before the State Bar Council, Lordship, which I have already received notice, Lordship.
Ma'am, I think it will be better for this court to adjudicate if you can bring all those in the form of an affidavit.
Yes, Lordship.
So that this court is also well seized of what is happening
Yes,
beyond this
Lordship.
petition.
Lordship, I have enough evidence, Lordship. I'm innocent in this case.
So
Lordship,
ma'am, let us do like this. Let us not fight over each other. You serve the copies today.
Yes, Your Honor.
Receive acknowledgement. Okay?
Yes, Your Honor.
Let her at least file the affidavit so that she also gets an opportunity to know what you have alleged.
Yes, Your Honor.
Okay? And let her file the affidavit. Then after that, let us adjudicate the matter judiciously without
Yes, Lordship.
prejudice to any of the parties.
my prayer is that because of this application, Lordship, your daughter's case should not be prejudiced, Lordship.
No,
This
no,
is my request, because
yes.
this court is only concerned with
No,
your daughter,
we
Lordship.
are not going into the merit of that case.
Yes,
Get it?
Lordship.
We are only trying to ascertain whether the allegation made against the Learned Council in the application is true or not.
Yes,
That
your
is the
Lordship.
that is the only thing which this court has to go into.
Yes, your Lordship.
If not, so far as the medication of your son, is it?
Daughter, Lordship.
Daughter is concerned, we are not passing any adverse orders.
Okay.
Let the treatment continue as it is. But let us also see whether the allegation raised in this application is true or not. Okay, and
Yes,
for
Your-
that, you will have to give her opportunity to rebut your allegation.
Okay, Your Honor.
Okay,
Okay.
so you kindly serve the copies today.
Okay.
Okay, and then let her file affidavit. And in her affidavit, she can bring up all these things that is relevant to the case at hand.
Lordship.
And we can adjudicate judiciously. Okay,
Okay. Thank you, Your Honor.
is MS, your good name,
Barbara Nunes.
so and so. You are the applicant.
Yes, Your Honor. I'm petitioner number 2.
No, you are, okay, in this petition, in this IA 65,
Yes, Your Honor.
in this, just.
May I please submit My lord.
Yes.
Sir, I am Samuel Abraham from Chennai. I am representing R1 hospital. We have been giving treatment as per the orders of this honorable court for the child already now. In an emergency basis, the direction has been complied. We are complying all the instructions. Now the child is more than 3 years, my lord.
Yes.
My lord, now she is more than 3 years. Her weight is also improved from 1 kilo 100 grams to 15 kilograms now. It is normal. Now it is a normal situation, my lord. So we have been giving treatment continuously, and the cost is, we are completely 100% private hospital, my lord. Only land has been given on lease basis by the state of Nagaland. Only land has been given on lease basis. No funds from the Nagaland, no funds from Union of India, no funds from foreign countries, my lord. Completely private. Now the arrears of payment comes to more than 1 crore, my lord. So we have to take up the IA 58 for disposal, where we have filed all the documents, my lord. And we are suffering a lot because of the monetary expenses. It is going beyond 1 crore. And now it is more than 3 years, my lord. We have to reconsider that. We have to take up IA number 58. And we have also filed all the documents to say that there is even 1 iota of negligence in our case. We got all the certificates from AIMS, etc. We are not going into the matter now. May your lord please take up that 58 immediately or next hearing so that it can be disposed and our rights are also established. Our side is also clear.
What is IA 58?
Your Honor, IA 58 is to reinstate the prayers that were removed without our knowledge or consent by committing fraud on the court.
What was removed?
The prayers for investigation and for compensation and all of those.
So that is also a part of 65?
No, that's part of IA 58, Your Honor.
May I explain?
Your Honor, I would like to object to one thing that he mentioned. The Christian Institute of Science
My lord,
is not a full private hospital. All of the board members are the government officials of the state of Nagaland. They do not have only the land, they also run many schemes. Government schemes are appointed to them. For example, the Ayushman card, and also the scheme, I forgot the name, Your Honor, I'm sorry, but the scheme where the government doctors and nurses are trained is all run by a Christian Institute of Health Science and Research.
It's a vast difference between the fulfilling government scheme and being a government hospital. We are completely private. We are taking government schemes.
Let me first understand the case. Please wait.
Yes, sir.
Don't
Yes,
come
Lord.
in between. Don't come in between. Let me first understand the case. What is 58?
Your Honor, 58 prayers are to prayer A, reinstate prayers originally included in writ petition number 6, 2022, which was
This has got nothing to do with the treatment.
No. Your
Is
Honor.
it? Yes, ma'am. 58. This has got nothing to do with the treatment.
Yes, Lordship. Now, in fact, this IA 65 is also filed to frame me, Lordship, so that to mislead this court, to restore the prayers, Lordship.
So
That's not true.
58 has also connection with 65.
Lordship, in fact, even in the
Yes, Your Honor.
58, I have gone through, Lordship. The allegation was made against HRLN advocates, Lordship. Then again, in IA 65, the sole blame was, the allegation was made against me, Lordships. That is the case.
What I mean to say is that this is interconnected.
Lordship.
58 and 65, because the prayer in 58 has got nothing to do with the treatment of the child.
No, Your Honor, it does have to
Even
do
65,
with
Lordship.
it has to do only with investigation of the medical
Correct.
negligence and
It has to
compensation.
do only with the investigation.
Yes, Lordship. 58 is to restore the prayers, which I have no say in it, Lordship, because this is the discretion of the court. If the court deems it, but Lordship, allow me to kindly take you back to the 6th of June, wherein this court has made amply clear, Lordship, that this court is only concerned with the treatment of the baby. As far as the medical negligence issue is concerned, you take it to the civil court or the consumer forum, Lordship.
In which order does it state that?
That
Can
was
you
the explanation
please-
given by the court, Lordship.
In which order is that stated?
The proceeding is live stream. I'm not lying, Lordship. But as I stated, Lordship, with the prayers to IA 58, I have no say, Lordship.
Okay, let us do this. Let us take up this case in this manner. Let us first dispose 65. Correct?
Your
Because
Honor, why-
actually, when you are making allegation against the lawyer, I think the lawyer should be given a chance to also rebut your allegation. So far as the treatment is concerned, I think the treatment is going on. Correct? Has it stopped? Has it stopped?
It has not stopped.
It has not stopped.
No.
Okay, to that extent, good. So IS 65, let us first dispose this case. Yes, Learned Counsel, we are disposing, we will first dispose this IS 65 of 2024.
Yes, Lord. Yes, Lord.
By allowing the applicant to serve a copy of the application to the Learned Counsel against whom allegations are made. What was the last order passed in writ?
6/6/2024.
6/6.
2024.
Six, 20. Six, 2024.
Yes, Your Honor.
In the main WPC 6. In the main WPC 6.
No, Your Honor, in IA 65.
IA 65 years.
Yes.
But in the main WPC 6, along with IA 58 and okay. List the matter along with the present IA 58 and 65. Why don't you appoint a lawyer to assist you? Or
Yes,
should
sir.
you appoint a lawyer?
Your
My
Honor,
lord.
we were appointed advocate previously by the court.
Who is
An
that?
amicus curiae, Moa Jamir. And
Jamir.
it did not go very well, so we would rather just take the case and the responsibility upon ourselves.
Okay. Ma'am, you are appearing in person?
Lordship, yes.
Yes. The respondent number,
7 in IA 65, Lordship.
where is that amended? I don't see any respondent number 7.
Your Honor, the amendment was filed. So it should reflect already.
Okay, we will, but I am not finding a respondent number 7 in the petition. respondent number 7. I'm seeing only up to respondent number 6.
In IA 65, Your Honor?
I'm on IA 65.
Yes, Your Honor, on IA 65, opposite party number 7 wasn't yet impleaded.
Impleaded?
Yes, she was impleaded after IA 65 was filed. That's why it's not.
What is your application?
For the impleadment?
Uh-huh.
Yes, I submitted it. A copy is here.
You have submitted before the registry?
Yes, Your Honor.
Okay, 7. Okay. Seven. Okay.
Lordship, allow me to kindly make a few submission, Lordship. If this court wants to proceed with IA 65, I leave it to your discretion, but then Lordship, there are multiple proceedings
That's why.
with the same prayer, Lordship.
Madam, this court has actually told you to file your affidavit, bringing up all those facts on records so that this court will know what is
Lordship.
happening
Yes,
outside
Lordship.
this case.
Yes, Your Lordship.
Okay, without your affidavit, it will be very difficult, and just making oral submission also, it may not be proper.
Yes, Lordship.
So you file an affidavit bringing all those facts, so that
Okay.
this court examine at least. Okay?
Lordship, yes.
Okay. Mm. Yes, learned counsel, we are actually first, we will be disposing this IA 65.
Yes, my lord.
Where allegation has been made against, certain allegation has been made against the council. We will first dispose that, okay?
Yes, my lord.
We will give the opportunity to the learned counsel, to the learned advocate, against whom allegation is made to file her affidavit. Had had Mr. Tejangule and MS Barbara Nunes, the petitioners in person. Also heard MS Nito Koza, advocate, in person. And yes, ma'am. And MSV Sokre, the learned additional advocate general, for the respondent number 2 and 4. Yes, you are the counsel for the All Indian Institute of Medical Science.
Yes, sir. Yes, my lord. Yes, my lord. R1.
R6 in the IA.
Yes, my lord.
Lordship, I think he's for the CHISR, not AIMS.
Yeah, respondent number 1, hospital.
Okay, okay. And your good name?
Samuel Abraham. Samuel Abraham.
Samuel Abraham.
Yes, sir. Yes, my lord.
Yes, and Mr. Samuel Abraham, the learned counsel for the respondent number 1. Stop. The petitioners shall furnish the copy of the IA number 65/2024 to MS Nito Koza, the respondent number 7, as well as MS V Sokre, the learned additional AG, for the respondent number 2 and 4. When will you submit? In the course of the day?
Yeah, we will wait for her. We'll submit it right after call.
Today.
Yes.
Today. In the course of the day. and shall obtain proper acknowledgement of receipt of the application from MS Nito Koza as well as the learned additional age. Listed after 3 weeks.
2 weeks, Your Honor.
3 weeks.
Lordship.
Listed after 3 weeks for enabling MS Nito Koza to file written objection to the application submitted by the petitioner. Okay.
Obliged, Your Lordship.
Same. All this will be listed on the same date. Okay.
Thank you, Your Honor.
Kindly furnish the copies.
For admission, item numbers 20 to 22.
May I please, Your Lordship?
22. Yes.
Your Lordship, in all these matters, I have yet to file my counter, Your Lordship. So Your Lordship may kindly grant 3 weeks time, Your Lordship.
MS Inaholi, the learned government advocate, is allowed 3 weeks time to file affidavit in opposition on behalf of the state respondents.
Much obliged.
For admission, item number 23.
Yes.
Your Lordship, in item 23, Your Lordship, here I'm praying on behalf of V. Jimo, Your Lordship. He's yet to file counter, so kindly grant 3 weeks time.
Mr. Yangarwati, you are for respondent 5.
They have not served me the extra copy.
Ma'am, please, sir. Okay. MS Inauli, the learned government advocate for the respondent number 1, 2, 3, and 4. Correct?
Your Lordship,
1, 2, 3, and 4.
I'm praying on behalf of V. Jimo. So
Okay, all the same. Is allowed 3 weeks time to file affidavit in opposition. Stop. The learned counsel for the petitioner shall serve the requisite copies of the writ petition to Mr. Yangarwati, learned CGC, for the respondent number 5. When?
In the course of the day.
In the course of the day. Okay, in the course of the day. Listed after 3 weeks. Okay.
For admission, item number 24.
Your Lordship, I'm praying on behalf of AIM, Your Lordship. Here also, the state is yet to file counter. So kindly grant 3 weeks time.
MS Inauli
Please, Lordship, I'm appealing for respondent
makes a
number
mention on
9.
behalf of AIME, the learned government advocate, representing the state respondents, and 6 for 3 weeks time to file affidavit in opposition. What is your prayer?
I'm yet to receive instruction.
MS. You're for the respondent number
9.
9.
Yes,
MS
accountant.
Sansom, the learned counsel for the respondent number 9. Also submits that she is yet to receive the instructions and therefore 6 for some time to file affidavit in opposition. Listed after 3 weeks.
For hearing, item number 40.
Well, this is second round of litigation for the reason that the petitioner page 14 of my writ petition.
What is the matter? Just
Well,
give me the gist.
The petitioner was appointed way back in 1988.
1988.
88
As what?
as sweeper.
As sweeper.
My lord, the appointment is clear that it is against the post sanction by such and such dated 9/6/88. My lord. However, the petitioner was given contingency paid basis of rupees 375 per month. 375 at that particular point of time was the basic scale of pay. Then what happened is that instead of that, she was given only this fixed pay. The appointment is clearly against post sanction dated 9/6/1988. So what happened? The petitioner approached this court. Then this honorable court at page 23, WBC 215 of 2018. It para effective direction is page 31, para 13. Upon due consideration of the case in its entirety, I am of the view that the case of the petitioner for regularization, my lord, should be considered by the respondent as a special case, keeping in mind the particular facts and circumstances of the case. This honorable court go beyond even the first appointment, giving it none, just see that, take it that she was not appointed in a non-sanctioned post. Non-availability of vacancy in the post of sweeper presently cannot be the ground not to consider her regularization. It will be incumbent upon the respondent to create a supernumerary post to accommodate the petitioner for her regularization if so required. The post so created will be personal post and shall cease to exist once a regular vacancy occurs in the petitioner adjusts against such regular vacancy. So what happens is that this honorable court direction is clear for regularization, not a new appointment. Annexure 9, page 34, dated 28 June 2022. Because of this honorable court direction, this order was issued. 28 June 2022 order consequent upon approval of government for creation of one supernumerary post for regularization by such and such, Cabinet Secretary such and such, Home Department Leader such and such, Srimati Petitioner appointed as contingency sweeper is hereby regularized. That is prospective with effect from 14/6/2022. At Mohotong Branch Press Office under the Directorate of Renting Stationery in the pay level of such and such, plus all other allowances as are admissible under the rules in force from time to time with effect from 14/6/2022. That is the date of regularization. Her service shall be regulated in the old pension scheme with the period rendered on fixed pay in basis. Her service shall be regulated in the old pension scheme with the period rendered in fixed pay basis, counting towards qualifying service for the purpose of pension benefit as per the details given below. Srimati Petitioner, date of appointment is fixed 26/10/1988. Date of regularization is 14/6/2022. Effective date of qualifying service is from the date of initial appointment. So what I'm praying before your lordship is that this honorable court order is clear that for regularization, not the new appointment.
So you want a retrospective regularization of it?
Yes.
No, that cannot.
No. Date of appointment is clearly.
Well, you were appointed on contingency.
Yes. But the fact remains that the appointment is made against the post sanctioned by order such and such.
That's all right.
So when it is
Against that post, you were appointed on contingency basis?
No.
When were you appointed?
That is 26 October 1980.
When did you first approach this court?
Way back on. On 7/11 of 2018. On 11 of 2018.
And when did the government issue the order? You were appointed, the petitioner, you were appointed on supernumerary post. The court had directed to consider your case against a supernumerary post.
In case the court was gracious enough to see that if there is no post, supernumerary post may be created. But fact remains that the petitioner was appointed against the sanction post from the day.
No, this court will not give you that retrospective benefit.
Well, when the word meaning is regularized, it is not necessary that it should be. When it is a regularization of an
Regularization with prospective effect, not retrospective.
So what I'm submitting is that somebody was serving in a sanction post. Just the 375 was the basic scale of pay in the ROB. After 11 point.
You have accepted your contingency appointment without any demur.
So we have the petitioner have been approaching all along.
The petitioner has approached this court, and this court says that if there is no post, his case may be considered against a supernumerary post. So the consequent to that, the government has regularized your service prospectively. What wrong is that?
No, Lord, what I'm saying is, when somebody has been serving, regularization have to be from the data.
No.
Not the.
That is your submission, but this court is not inclined to accept that. Give me a ruling citation. When somebody has been serving, he has to be regularized with effect from the date of appointment. Give me that citation.
My petition para 11.
I'm not on your paragraph. I am kindly give me if there's any citation of the Honorable Supreme Court or of this court.
In 1986, one SCC 639
1986 SCC.
One SCC.
1986 one SCC.
639.
639 paragraph. Para.
I've not given the para here, but the fact.
Yes.
Page 37.
1986, 1 SSC 639 para.
No, no, I've taken it up from the need. So para is not given. But
We don't rely on all those need and all those things. At least the book is there
my lord,
to help you. Why don't you actually come with the
right,
book?
my lord. Can it be taken up on Tuesday? So that I can assess your worship.
Mr. Mua, you also come with a citation saying that if a person is appointed on contingency or work charge basis, he cannot be regularized from the date of his initial appointment, which is on contingency or work charge. Come with that citation. There are 101 of the citation. Don't just come casually. Don't just come casually. At least assist the court. I'm saying that the government advocates.
What I intend to say is by on the proposition of what law is coming. Now, he claimed to be appointed as a contingency employee in 1988.
And he's claiming regularization.
No.
Listen.
With that stand,
Listen. He is claiming regularization with effect from 1988.
with that stand, he came to this court. Now we have contested the case because 1988 appointment we searched directorate as well as with the government. We did not found. We did not find. So we contested the case, but then court was liberal and it was granted. Direction was issued to our state respondents to create a supernumerary post and regularize the petitioner. Now, accordingly, by following the direction of the court, BAS and WBC 215, 2018, we have created a supernumerary post.
Supernumerary post.
Supernumerary
You have
post.
created a supernumerary post.
Yes, and he was regularized in that post. Petitioner was regularized in that post with effect from 14/6/2022. Because though it was filed on 2018, order was given, this Honorable High Court has given the direction only on the lordship 23/1/2020. So accordingly, we have given the supernumerary post, created a supernumerary post, and he was declared in that post. Because direction of the order in the last paragraph was very clear, Your Lordship. You'll find in page, page 31. Paragraph 13 of the order.
Just wait.
Page 31, Your Lordship. Can you see page 31? Paragraph 13.
Page
31. Read petition, page 31.
My read petition.
Page 31, paragraph 13. This is very smooth. May I read, Your Lordship?
Yes.
Upon due consideration of the case in its entirety, I am of the view that the case of the petitioner for regularization should be considered by the respondents as a special case, keeping in mind the particular facts and circumstances of the case. Non-availability of vacancy in the post of favor presently cannot be ground not to consider her regularization. It will be incumbent upon the respondent to create a supernumerary post to accommodate the petitioner for her regularization, if so required. The post so created will be personal post and shall cease to exist once a regular vacancy occurs in the petitioner adjusted against such regular vacancy.
So in terms of this order.
Now, when we contested the case, there was no vacancy. So consequent upon that, our submission, state submission, this to create the post was given. So we have created the post, and Lordship, you will find in page 35, the order. Next, page 35.
Date of appointment fixed, and date of regularization 2022. Date of effective effective date of qualifying service. Okay.
So date of regularization is given your lordship,
Ah.
14/6/2022.
Ah.
So now she is regularized, petitioner is
She is
regularized.
regularized.
Now what I'm surprised is, now he is claiming to regularize her service from the date of her appointment.
Initial appointment 26/10/88.
Yes.
Is it?
Yes.
Let us see your prayer, Mr. MT. Which page? Which is your page? Let us see your prayer. I am not getting your prayer in the petition. Which page? Which
From the
page?
date of her appointment.
Yes, yes. Which page?
Page 12.
Page
Page
12.
1, 2.
1, 2, 12. Page 10. To regularize the service of the petitioner as sweeper from 26/10/1988.
To my estimation and understanding,
That
your
is why-
lordship,
that is
the
why.
petitioner was sleeping outside the home. Now, we were kind enough to bring him inside the
It's
house.
all right. It's all right.
Now, after coming to the house,
That is why it's simple.
he's claiming for the
See,
part of the
this-
house.
This court
It is something
wants,
like-
this court wants you to assist this court. This court wants you to assist with a
Lordship.
simple citation of the Supreme Court. That the date of regularization from 26/10/1988, which is retrospective regularization, cannot be made applicable to the petitioner in law.
Yes, your lordship. Yes. But the judgment, the decision of the Honorable High Court, this Honorable High Court, was not for retrospective. Then regularization is always prospective, prospective, as your lordship is well
You are
aware.
right. That is why I'm asking you, give me a small citation.
Lordship.
Yeah, I'm asking, prospective regularization should always be prospective.
Prospective.
You are right. I agree with you. So I'm asking you, give me.
That is
a
why I'm
place.
surprised, why petitioner is coming, this petition must
Don't-
be
don't-
dismissed
don't-
at threshold.
Don't be surprised, smash her with citation.
Lordship.
Yes, Mr. What is your citation?
This citation is Surrender Singh and another versus Chief Engineer CPW. My page 37. 1, 2, 3.
Your
4.
page 37.
Yes, 4. Paragraph 1, 2, 3, 4. This argument lies here in the mouth of the central government.
See, Mr. Imti.
Yes.
The citation which you print out from this thing, and then online, and then the citation which is there in the SSC, it differs. Oh, that is why I want the original citation. It differs.
Yes.
It differs. That is why since the citation which is given in the SSC is more reliable. I want you to produce.
I may be allowed to produce that.
This. This is regarding equal pay for equal work. Maybe, Mr. Imti, you should have been satisfied with the order dated 28/6/2022. Okay, we list it, we give it as a part heard matter. If not, I'm giving you that opportunity, you produce the citation. If not, this court, frankly speaking, is not inclined unless you satisfy this court with some decisions of the Honorable Supreme Court. That Mr. Imti Longchar, learned counsel for the petitioner, and Mr. Mohamchan,
For all the state respondents. All the state respondents.
learned senior government advocate for the state respondents. Listed again on
Done. My order.
1/8/2024 as a part heard item. 1/8/2024 as a part heard item. Okay, or earlier than that.
The previous one was 29. My fixed item. Which was made in the mentioned stage. So it is over.
Same.
No. Other item. Before your
if it is on different facts,
29.
then-
So it is fine.
Okay,
Okay.
we will list it on this on 29.
No, my lord, the other item has been fixed on 29 before your lordship.
Okay, so listed on one.
My lord.
One. Okay, Mr. Mohamchan. 1/8/2024. Okay.
Much.
The law is very clear, but I am still giving you that opportunity to see whether you can, if you can satisfy this court, to give you some relief. So we will hear it again on listed on so and so, one so and so as a part heard item. Okay.
Much obliged.